Hi, good afternoon. I'm Jatinder Lal, a Policy Associate here at the SRA in our Regulation and Education team. Here just to give you a quick update on law firms and those that are thinking about using a third-party managed account. More and more law firms are really looking at how they deliver services and also engage with clients, but also with that comes how they handle and receive client money. It's a risk in the sense that law firms are exposed to numerous risks in terms of holding client money, but with the risk comes cost as well. So what we're trying to do is just set out, is a TPMA, third party managed account, right for you as a law firm? So what is a TPMA? A third party managed account is an account that's provided by a third party, where you have two or more people that are transacting or giving instructions in terms of how the money's moved. So what you'll have is the law firm and the client, and or anybody else that's involved in the transaction giving instructions about the movement or receipt of money. So that's something that's quite important to understand. There's nothing in our current rules which prohibits the use of a TPMA as an alternative to operating a client account. It's something that was talked about many years ago, and then it was followed up by some research that the Legal Services Board had done in terms of looking at the alternatives to law firms, but and other regulated persons operating and using a client account. There are benefits in using a third-party managed account, TPMA. What are the benefits for you as a firm? I think the first thing that we need to think about is looking at the risks that holding or operating a client account bring. First, the biggest risk at the moment is cyber fraud or cyber attacks. These criminals, the attackers, they know that law firms handle vast amounts and large amounts of client money, and especially if you're involved in things like conveyancing, immigration, personal injury, where there is a lot of money coming through to the law firms, and these attackers know that money is being held. It could be held for a period of time, and over that period of time, the attackers will become accustomed to sort of the trends and how money is being moved from one account to the other within the law firm itself. Using a TPA can basically move that risk away from you as the law firm. Nobody needs to know that you're using a TPMA apart from us or the clients that you're involved with and the provider themselves, but it's not something that you have to make public, in the sense that this is the provider that you're using and this is the account number, etc., etc. So in terms of an attacker looking at how this firm is holding client money, it's not something that's going to be publicly available. Linked to that then, because you are removing that risk of holding or handling client money or even receiving client money, we've been hearing from professional indemnity providers that there is scope for premiums to be reviewed. A large chunk of professional indemnity insurance premiums go on the risk of rectifying breaches of the solicitor's accounts rules, which is because of the misuse of money or money just going missing from the client account. If law firms are not exposed to that risk anymore, we see no reason why insurers would need to indemnify against that risk, or at least they should be looking at how they're insuring the firm going forward. Just important to bear in mind as well is that the figures that we had from our research analysis team was that in 2016 and 17, just over 20 million of client money was reported to have gone missing through cybercrime. So that's it's a huge number, but in a very short space of time as well. In terms of clients, again, it's important to understand the flexibility that it brings. A lot of clients now want to be more in control of the transaction or the services that are being provided. It's important because they see in other industries as well, where they're party to the movement of money, the instructions that are going out, experts that are being appointed. So it's key that that the same benefits should come through here in terms of where a law firm does use a TPMA. Clients are going to be in control of how their money is being managed, how their money is being moved, and they'll be party to that transaction in terms of how the money is then passed on to a third party, or should we say the secondary person in a transaction. It also brings an element of transparency as well, in the terms of that what will happen is that this is again showing to the client, but also anybody else that's involved in the transaction, how the money is being handled and used. So in terms of conveyancing transactions, for example, lenders might be more comfortable in engaging with smaller firms or firms that they might have previously deemed to be high risk for whatever reason, to think that, okay, these firms are now using TPMAs to manage conveyancing monies because we're going to, it's an element of, again, removing that risk. And what happens is that the lenders will say, okay, we're now in control of how this money is being moved because we can see that the law firm's using a TPMA. So we're hoping that this is where law firms start thinking and looking at how they develop their processes, their systems, but also how they develop their business going forward in a way which we think is quite innovative, but also fit for purpose going forward. In terms of the regulation of TPMAs or TPMA providers, we don't regulate the TPMA provider. These are organisations that are regulated by the Financial Conduct Authority. They set out regulations in terms of how organisations want to be involved in payment services or the movement of money, so money remittance, and there's legislation and FCA rules around who needs to be authorised or how people are regulated in terms of becoming a TPMA provider. What we do expect though is that if you are using a TPMA, is just to let us know the name of the provider, their FCA registered number, authorisation number, and when you started using their services. In terms of, again, the questions that we've had asked is that can we use TPMAs now? Again, yes, it's not something that's prohibited in the current rules. In the rules going forward as well, we're clear about the expectations in terms of what we expect of a law firm that's engaging in a TPMA provider or looking to use a TPMA as an alternative to holding client money themselves. One thing that's key is that the guidance that we issued in December 2017 was to help law firms think about the sort of expectations that we require of them, but also in terms of the information that they need to be telling their clients about how their money is going to be held. Key thing to remember is that even though money held in a TPMA isn't defined as client money, there are still provisions in the SRA handbook that would apply to the principles around making sure that money or client assets are protected and safeguarded, that will always be there. So it's making sure that law firms that are thinking of engaging with a TPMA provider do their own checks in terms of the authorization of the provider, but also just doing their own research in terms of the product, the costs that are associated with that as well. The future of TPMAs depends on you as law firms, but also on providers as well. Simple economics, that where there's demand, it should increase the supply and hopefully bring down the costs of running or operating TPMAs. It'll be interesting to see how the market pans out in the next couple of months, the next couple of years, in terms of law firms that are using TPMAs. It's something that's not restricted to one area of law either. A lot of firms are saying that, this won't be, should we say, workable or feasible for me because I'm a sole practice that's involved solely in conveyancing. Again, it's not saying that you have to use a TPMA instead of a client account. They can both be used together. So for certain clients, you might want to use a TPMA, or for certain transactions, you might prefer to carry on using the traditional client account. Again, something that we've heard is that the use of a TPMA is again confirmed in the new rules going forward, and it's something that we want to promote as best as we can. If you have any questions, do get in touch with us using the email address policy@sra.org.uk. So that's policy, policy@sra.org.uk. Get in touch if you have any questions around the use of a TPMA, but also look back at the guidance that was issued in 2017 just around how TPMAs can be used and the information that we expect from you. But also think about getting in touch with providers, speak to your banks. If you're a law firm and you've got a good relationship with your bank at the moment, ask them as to whether or not they're thinking of moving into the TPMA space, or they already have products and they're just waiting for people to start using them. Something to bear in mind as well is that we'll be speaking at our Legal X, at the Legal X conference in March. Myself and my colleague Sean Hanking will be there to answer any questions around the new accounts rules. And again, just to advise that, like I said, the new accounts rules don't prohibit the use of a TPMA. What they do is set out the expectations in terms of what we want to see from law firms that are using a TPMA. So come and speak to us. If you don't get a chance to email, come and speak to us at the Legal X conference. And to the providers that are listening in or watching this at a later date, again, please engage with law firms. There's plenty of networks out there. There's the small firms network, the sole practitioners group, but even for the bigger city firms, City of London Law Society are out there to help make that relationship or build those relationships with law firms that are looking to build and start using TPMAs as an alternative to holding client money themselves. Hopefully that little snippet of what's expected and some of the benefits for you and your clients has been helpful. Do get in touch, like I said, if you have any questions, and we are here to help you think about delivering services in a different, innovative way, but making sure that you are compliant and that clients' interests are always being served. Thank you for listening, and see you soon.